Good afternoon, everybody waiting in line for snacks. Um, This, as all of our presentations, this will be posted on our website, so if, for those people out in the hallway, let them know that that they'll be able to get this at another time. As always, when I present or anyone else from DLGF, I hope, presents, we want to talk about our legal disclaimer. I nor others from DLGF will be providing legal or fiscal advice. If there's a conflict between the materials contained in this presentation and what's contained in statute, statute governs. This is my contact information here. Please feel free to give me a call. Also, I have two, since the last time I spoke with you all, I have another Deputy General Counsel named Emily Chrysler. She joined us from the Attorney General's office. So her and Dave Marusars are both in the office and doing great things. Emily handles a lot of the deduction and exemption questions. Dave works a lot on the budget issues. So if you contact your field reps and ask the question of them, they'll know. If they don't know the answer, they'll be able to point you in the right direction, whether that's to me or Fred or one of my deputies. The legal division has a number of responsibilities, but the primary ones include managing legislative and litigation matters, advising the commissioner and division heads on the law as it applies to their areas of responsibility, and performing ongoing general risk assessment on all matters related to DLGF. For those of you who don't know, the commissioner did mention it this morning. Matt Parkinson was scheduled to speak at this conference along with Fred, but he has departed DLGF and moved on to greener pastures. Matt is now the CFO for Danville Community Schools, so we wish him the best. Matt was a tremendous asset to DLGF, and the local units will miss him, I'm sure, as we will. Therefore, we've worked to ensure or try to ensure that Matt's responsibilities are covered, and so we're kind of fumbling around with who's presenting when. So I'm presenting today along with Fred. Earlier, Lori asked who wants to go first, and there's no way I was going to follow Fred, so just to be a mass exodus, so here I go. As you may recall, the DLGF agency bill in 2018, House Bill 1104, was held up in the legislature mostly due to some additions that were not proposed by the DLGF, and it didn't pass. And so this year, our agency bill, which is House Bill 1427, was adopted by the legislature and signed by the governor, yes. However, combining House Bill 1104 from last year along with this year's changes, in addition to the myriad of additions that the legislature puts in every year, means that this was the second longest bill of all several hundred bills in front of the legislature. So there are a lot of changes, and I'm trying to highlight some of the ones that are most applicable to you all. A number of items in 1427, however, were proposed by the DLGF, about half. Additionally, my legal staff and I worked with legislators on other sections of this bill and other bills that affect DLGF to ensure that the law could be implemented. That's our major concern, is whether or not we can implement what they're trying to pass. We were very busy doing that this year. I'm lucky to have the second deputy. Please keep in mind, however, that, like I said, only half of the sections in 1427 were DLGF proposals, so please don't shoot the messenger when I tell you about some of the other provisions. First, House Enrolled Act 1427, the Form 22 specifies that county auditors must submit the certification of tax distributions and settlements to the transparency portal not later than these dates contained here. I don't have a lot of narrative to go along with this, but just keep that in mind, that there are due dates for the Form 22. Homestead deductions. So the requirement for resubmission of the homestead deduction upon divorce, marriage, or joint ownership was added into statute in 2017. But the legislature was concerned that it was not intuitive that you would need to refile for a homestead deduction upon marriage. So as a result of the previous version of the law, a person did not refile. The new statute directs that the homestead is to be reinstated, and one would assume then that any penalties that resulted from the denial of the homestead based on those criteria would need to be refunded. More deductions, mobile home deductions. Mobile homes will now have the same deadline for a deduction as real property. The taxpayer must file for the deduction in the year prior to requesting the deduction and not after January 5th of that next year, as is with real property. Legislative studies. There were a number of things that were sent to legislative study in 1427, but specifically, all legislative studies were assigned yesterday in the Legislative Council, and while this particular legislative study, the elimination of the mortgage property tax deduction and the advisability of increasing the homestead standard deduction was not specifically assigned in the Legislative Council yesterday, there is a catch-all study, which is a multi-year review of tax incentive reports from the Legislative Service Agency, for which a statute requires a committee hearing. You may see the topic of mortgage property tax deductions and homestead standard deduction increases in that interim committee. Currently, some auditors, homestead database updates, there was a minor change. Currently, some auditors submit deductions as they are approved, and some submit in one or more batches throughout the year. This change is to help ensure that there's one day, March 15th, where the homestead database is current and up to date. Thus, it should prove to make it easier to identify those folks who are claiming more than one deduction. And the manner prescribed by the DLGF hasn't changed. It's through the homestead database. Exemption filing grace period. Every year the legislature passes specific legislation. This year's no different, we'll get to that, for one or more nonprofits that miss the filing deadline. This change will hopefully limit the amount of special legislation, that was the intent, and ensure that nonprofits remain tax exempt with no penalties. If there are penalties associated with the grace period, that money is to be deposited in the county's property reassessment fund. So this is interesting. This in the next 3 slides, I believe. I'm unaware of the specific reason for this part of the bill, these 3 parts of the bill. It seems specifically geared, this one seems specifically geared towards an individual taxpayer, given the tight time frame. So for somebody for which an exemption application was filed after April 1st, 2017 and before April 10th, 2017, and if they resubmit by September 1st, they'll be able to receive the exemption. If the nonprofit that this applies to fits the criteria of this legislation, the county will be required to refund any amount paid without interest or penalties applied. And that means that they won't have to pay any interest and penalties, but also that the county won't have to pay any interest back to the taxpayer. Again, another piece of special legislation this year which allows churches to file for an exemption. This is between 2003 and 2015. I just wanted you to be aware of these things because when people come in and ask you questions about it, hopefully you'll remember this presentation and at least be able to call us or talk to your county attorney to work through it. If a church fits the criteria again, the county will be required to refund any amount paid without interest or penalties both ways. And finally, cemetery property. Again, special legislation. This is between 2013 and 2017. If they were eligible, they still have the ability to file before September 1st of this year. And then the same applies with regard to refunding any amount that they lost as a result of the improper filing. Okay, personal property appeals. During the 2017 legislative session, the General Assembly passed Senate Enrolled Act 386, which overhauled the property tax review and assessment procedures. In addition to reforming the appeals process, the legislation also changed the filing deadline for appeals of the assessed value of property from 45 days after the notice or statements were mailed to June 15th of the assessment year if the notice of assessment is mailed by the county before May 1st of the assessment year, or 2, June 15th of the year in which the tax statement is mailed by the county treasurer if the notice of assessment is mailed by the county on or after May 1st of the assessment year. The practical impact of the new assessment appeal provision under Senate Enrolled Act 386 resulted in a scenario where it was possible that either, one, a taxpayer is unable to appeal a personal property assessment, or 2, the value of a personal property isn't finalized for over 2 years. So this is a return of the 45-day amendment period for personal property appeals, just for personal property appeals. And it ensures that both of those scenarios, the taxpayer is unable to appeal or it takes 2 years, is eliminated. Tax adjustment boards. So no county has had a board of tax adjustment for around the past decade. Thus, there was no reason to keep language referring to the board in statute. As we originally proposed last year, DLGF originally proposed last year in House Bill 1104, all language referring to the tax adjustment boards was removed from statute. And this really should have no effect on your current practices, but I wanted to let you know that this was out there. This actually took up not a large portion, but I would say 5 to 10% of the entire bill, because the tax adjustment boards were mentioned in so many places throughout statute. Budget filing. The DLGF was successful in certifying all budgets by December 31st or January 15th, whichever was applicable, for all political subdivisions this last year in preparation for 2019. And following me, Fred, yes, Fred. Following me is the person that is primarily responsible for that achievement. It was an all hands on deck effort, and we're very proud of that. And it's a good thing for the local units as well, because they begin implementing their budgets at the beginning of the calendar year, so to have that certification happen by the end of the previous year is extremely helpful. However, it was not easy for the department. The sooner the DLGF receives the budgets which were adopted by the various units, the sooner we can begin the certification process. There have been instances in the past of units adopting budgets in August and September, but waiting to submit at the beginning of November. Waiting until the last minute is problematic for 2 reasons. One, if the DLGF finds an error, there's no time for the unit to correct because they no longer have time to hold the necessary hearings. And 2, DLGF cannot get started certifying the unit's budget until we receive the unit's adopted budget. So this change applies to all units, including schools, and requires you to submit not later than 5 business days after the budget is adopted by the local unit. Tax cancellations. So this eliminates the requirement in most cases for DLGF to approve tax cancellations at the local level. Often, local units seek to eliminate taxes on parcels for the purposes of economic development and getting the property back on the tax rolls. In past years, DLGF has received for approval numerous requests to cancel taxes for properties owned by a local unit. There are a number of steps required at the local level to cancel taxes, including the approval by the auditor, treasurer, and assessor, and then approval by the county executive. That then required the approval of the DLGF commissioner. I am not aware, since Wes and I started on the same day, nearly 2 years ago, since we've been there, there has never been an instance where we have denied cancellation of taxes, assuming that all of the proper steps were met by the locals. Plus, the state doesn't receive any of these dollars, so we don't really have any skin in the game. We were successful in removing the DLGF approval requirement, which should make this process faster and with less bureaucratic red tape from the state level. DLGF will continue to be the final approval, however, for other types of tax cancellations, including for state-owned property and railroads and others. However, we have not received a request for those types of cancellations that I'm aware of any time in recent memory. Judicial proceedings. Currently, county officials engage their own counsel for representation at PETA-BOA and the IBTR. If that case then goes on to tax court, counties must switch attorneys and utilize counsel from the Attorney General's office. This is not very popular amongst the counties. So this change in the law gives the county the option of either utilizing the Attorney General's services once they move to tax court, or continuing with their private counsel. County official training. This change, which was primarily championed by the Association of Indiana Counties amongst other supporters, ensures that there's statutory language which allows the county officials training fund to be used for training of local officials, including travel, lodging, and other related expenses for both the county official and their staff. If you have questions about how this works, this isn't really a DLGF implemented item. Contact your local attorney or State Board of Accounts would be able to help you with that problem as well. More on county official training. This change also provides that a newly elected county official must complete at least 5 hours of newly elected official training courses before they take office. Like I said, this was not a proposal by DLGF. However, I know that the commissioner, Wes Bennett, is a huge advocate for training for all governmental officials. As a former 3-term elected official himself, Wes will often point out that just because a person wins a popularity contest or election does not mean that they understand the intricacies of their new position. We all, and me included, can benefit from continual training to ensure we are providing the best possible service to the taxpayers. Endorsement fees. Currently, a fee of $5 charged by the auditor for endorsing a real estate conveyance document was optional if adopted by the legislative body of the county. This change requires each county legislative body to allow the auditor to charge a $10 fee. The fee must still be used for developing or maintaining plat books, but this piece of legislation specifies that those plat books can be either in a traditional book form or in electronic format. I included this slide in my presentation to you all last year. We were in a big hurry, so I didn't go over it in very much detail. DLGF is always happy to point local units in the right direction to identify the applicable law and issue guidance on how DLGF will interpret the law when it is appropriate for us to do so. This slide is an effort to ensure that the auditor's offices are utilizing the many resources available to them prior to bringing the issue to our office. DLGF spends a large amount of time presenting at conferences. Fred's an example. He's on the road for about 2 to 3 months a year? 2 to 3 months a year. We're preparing guidance memos and issuing FAQs, all of which are posted on our website for your reference. The vast majority of your questions are addressed in those materials. If you have questions about accessing that information, please contact Jenny Banks, who's our communications director. She's the custodian of our website and will be able to help you out. Number 2, ask around your office. Many of you have good internal controls or are small enough to where everyone always knows what's going on and can answer questions as they arise. However, auditor staff often email DLGF, and it's clear that they have not inquired within the auditor's office or other senior staff. Take advantage of your internal resources. Additionally, you have access to 2 excellent resources in AIC and the Auditors Association. I know that they're more than happy to work through problems. They may understand better than DLGF in some cases if something is a continuing issue. And then 3rd, contact your county attorney. I understand that some counties have better access to their attorneys than others, but that is a resource that you can consult with. Just to reiterate what I spoke about at the beginning, we can't provide fiscal or legal advice, but we can point you in the right direction. So the first call that you should make to DLGF is your budget field rep. All of them work for Fred. Many of them have over 2 decades of experience as a budget field rep for Department of Local Government Finance, and maybe even a few of them before it was the Department of Local Government Finance. And they have a wealth of knowledge, and if they can't answer your questions, they'll elevate it to Fred, and Fred will either be able to answer it himself or he can distribute it throughout the office to the appropriate person that will be able to work with you on that issue. If you have any questions, please don't hesitate to call us. Fred West or I are talking to the budget field reps out in the table in the hallway. Write your questions down. We'll be putting out, like I said before, an FAQ document for the auditors conference and distribute that document to you all via email, and then also we'll be posting it on our website. With that, I'd like to introduce the better dressed than I, Fred Van Dorp.